Good morning, everyone. Thank you for appearing and participating in this workshop related to docket number 2025-192A. And the purpose of this workshop is to discuss procedures for public witness testimony at customer public hearings. The clerk's office issued the notice for today's workshop on July 10th, 2025, after the commission issued order number 2025-392, asking the clerk's office to schedule a workshop today. So let's see who's participating in the workshop. The Office of Regulatory Staff, would you please state your name?
Ben Muschin on behalf of ORS.
Thank you, Mr. Muschin. Dominion Energy, South Carolina.
Good morning. I'm Chad Burgess. I'm in-house corporate counsel for Dominion Energy. With me is Michael Anselmo from the law firm McGuire Woods.
Thank you, Mr. Burgess and Mr. Anselmo, for participating. Duke Energy Carolinas LLC and Duke Energy Progress LLC.
Good morning, Ms. Boyd. On behalf of Duke Energy Carolinas and Duke Energy Progress, I'm Sam Wellborn. With me this morning is Lyle Trawick of the law firm Robinson Gray.
Thank you both for participating. South Carolina Department of Consumer Affairs.
Good morning, Ms. Boyd. Roger Hall on behalf of TCA.
Good morning, Mr. Hall. Thank you for participating. Nexus Water Companies, South Carolina Utilities. Hey, Mr. Terraini. Well, I'll come back to you, Mr. Terraini. Thank you for being present and participating. And then Mr. Richardson, are you here representing Piedmont Natural Gas Company Incorporated?
Yes, ma'am. Jason Richardson of the law firm McGuire Woods, outside counsel for Piedmont Natural Gas.
Thank you so much for participating in this workshop. So we have received comments from Dominion Energy South Carolina Incorporated, and Duke Energy Carolinas LLC and Duke Energy Progress LLC. And Mr. Anselmo, we're going to start with you. Thank you for your comments on behalf of your client. Just to give you a little bit of perspective about the way the draft regulation was drafted, I just started searching the web. So, and I wanted you to know where
Ms. Boyd?
Hey, Mr. Terraini, how are you? Can you hear me?
I'm sorry, I don't have any audio from y'all.
Oh, so let me, if everybody doesn't mind, let me call Mr. Terraini right quick and see if he can sign out and sign back on, sign off and sign back on. Is that okay? If he signs off and signs back on, Ms. Purvis? Okay. Hey, would you mind signing off and signing back on? Okay, thank you. Okay. Mr. Terraini, can you hear me now? Mr. Terraini? You're muted, Mr. Terraini, too. I don't think he can hear. Do we have a phone in here? Do we have a phone? Okay. Well, can I leave you on my phone and then you can listen? All right, hold on. I'll put you on speaker. Okay, Mr. Terani, would you are you participating today representing the Nexus Water Company, South Carolina Utilities?
Yes, ma'am.
Ms. Purvis, can you hear Mr. Terani? Okay. All right. I'll leave you on speakerphone, Mr. Terani, so that you can. All right. So, Mr. Terani, I was telling our participants that how the draft regulation for customer public hearings were created, and I just used other commissions, viewed their sites and their processes for customer public hearings, and basically compiled the document that way. But I wanted to give them credit for using the language either on their webpage or in their statutes. So, with that being said, Mr. Anselmo, are you willing to proceed with Dominion Energy South Carolina's comments?
Certainly. I'll talk loudly and briefly for Charlie's benefit. The first comment is in regard to subsection G regarding a individual representing an entity pro se at the proceeding. Commission regs do not allow that currently, nor do the unauthorized practice of law. Duke put in I think a very good suggestion on how to revise.
Thank you, Mr. Anselmo. Thank you for letting us do that.
No problem.
Okay.
To summarize, G, we thought had some potential running afoul of the unauthorized practice of law rules. Duke put in a very nice suggestion, I think, in their comments to solve that. So I'm fine with that addition.
Okay.
And then in subsection K, we suggested just limiting the regulation to read public witnesses may be asked questions by parties of record, which obviously would include interveners who have been granted party status or by any of the commissioners. It seemed unduly prescriptive the way it was currently drafted.
Yes. Yes.
And then one was a general comment, as you know, from your experience. Typically, the company, Dominion, will state at the beginning they're reserving any objections to what happens. That's fine, and it's worked well, but there is some risk associated with not making contemporaneous objections unless it is preserved by statute or order or rule.
Yeah.
So all we're asking is to put our normal blanket objection into a rule so we don't, to the extent we ever have to challenge some evidence at the appropriate time at the merits hearing before the commission, we're protected, so we don't interrupt our customers. That's not the purpose of why we're there. We're there to help them.
Right.
So the addition that I suggested in my letter, I think accomplishes that and doesn't change anything as far as the actual proceeding. Okay. And then subsection L, I appreciate the staff receiving some feedback from this in prior dockets, and I think the intent is good. I don't want the commission to be in a situation where parties perhaps bicker over what constitutes significant and have to interrupt commission time. The ability to hold these hearings is in and of itself discretionary. Right. So you can just have the regulation read that you can cancel it, as I've suggested, with appropriate notice and within appropriate timeframes, and accomplish anything that the commission might need to do as far as canceling a public night hearing. So that's really all we have.
What did you think about that, where the question mark is? Or you want to talk to your client about it? It's at the very end. If the commission cancels a public hearing, an interested customer may testify in person at a customer public hearing at another location.
Yeah, we don't have an issue. In fact, I think we put that in 2 comment letters. That's why you should have the flexibility to cancel, is because those reasons exist. They have other opportunity to participate. So if the commission wanted to include that in the regulation, we wouldn't have a problem with that.
Okay, thank you. Mr. Mushton, do you have any comments?
No, I think we generally agree with those comments.
With
No,
the comments?
no further.
All right. Mr. Treywick.
No, we're in agreement with Dominion on that. And, preservation can sometimes be a trap. And so the objection thing really is kind of important. And we appreciate him raising that.
Okay, great.
Thank you.
Yeah, Lyle and I have done a bunch of appellate work, and
Okay.
error preservation is something that attorneys worry about constantly because it's a mistake that you make technically if you don't object. So preserving counsel while not interrupting in any way what the proceeding is, and then having the opportunity to make the objection when it's supposed to be made, which is at the merits hearing, would really be beneficial for everybody who participates in night hearings.
Yeah.
The only tweak I might make is that I think generally that's right. There are situations sometimes where, an objection might be needed just to keep the conversation going and everybody's, staring at you. And so maybe that language could say that, the party, I already lost it. I'm sorry. It could say may. All right, so Dominion had suggested that all objections to public witness testimony or submissions from the customer public hearing are reserved until maybe put may be reserved. I want the preservation question clear, but also not to unduly, restrict someone from still being able to make an objection if things are, getting a little off the rails.
Yes.
Yeah, I actually think that's a really good point. And the last sentence of the company's proposed change still preserves whether you do it or not. The discretionary may doesn't impact the intent of what we're going for in that last line. A failure to object doesn't constitute a waiver. So I think we're protected, and that's a good add.
Okay. Thank you. All right, Mr. Hall.
No comments. DC also generally agrees with Dominion's.
With the proposal, the one that you received this morning too. Well, I mean, it includes the proposal, so I follow what you're saying. Thank you, Mr. Hall. Mr. Tor. Oh. Okay, can you repeat that for me, please?
Yes, ma'am. I agree with the comments of Dominion and Duke.
Thank you. Okay, let's see. Mr. Richardson?
No additional comments, but agree with what's been stated.
Thank you, Mr. Richardson. Okay, Mr. Anselmo, thank you so much. Mr. Treywick, are you ready?
Yes, Ms. Boyd, thank you. And again, we appreciate Dominion's work on this too, and staff's work in proposing some language here and showing your work on where it came from. I personally found that super helpful and really appreciated that. We just one more thing to add. I think it'd be helpful, even as you were sort of describing this, there seemed to be some inconstancy in my mind of public witness testimony at a customer public hearing. So is this public hearing just for customers? And I think if you look at the case law, utility services, discusses customer testimony. If you look at Act 41, it also discusses, that customers would testify regarding customer service, utility operations, reliability, economic hardship, things of that nature.
I think it says something about their personal. Does it say knowledge? Am I recalling?
Yeah.
Okay.
Well, that's actually I have two things to propose. Okay. So that's number two, and we'll certainly get to that. But I think the concern here is that this truly should be customers' opportunity in a rate case to come talk. The concern arises where you have somebody coming in who's like, hey, I'm an economist and I want to come talk about this. Well, that's for a party or an intervener to proffer through the appropriate channels, because this is, after all, a contested case proceeding. It's not, a legislative hearing, right?
Right.
And so I think some clarification on that limits this to customers would be beneficial, and we would ask for that.
Okay, and I did not include that. So I'll take that back too.
Okay.
Okay.
And relatedly, go into my second issue.
Okay.
we think that testimony should be based on personal knowledge. And again, that's sort of, we're at the commission, so the commission follows the South Carolina Rules of Evidence. And so 602, Rule 602 requires a witness to have personal knowledge of matters to which they're testifying. And we think some clarification of that in the reg really might help set the rules of the road for those hearings. And I think maybe even explaining that, I'm not saying this for a reg, and I'm not telling or presuming to tell the chair what to do, but maybe sort of setting the table with that at the beginning of the hearing would be helpful. We've all been to public hearings before. I've been to them in multiple different settings and multiple sides. And, you invariably get the testimony about, my neighbor Dan up the road who had X happen. Well, that's hearsay. That's not your personal knowledge. That's, there's issues with that. And so maybe trying to flag that on the front end could be helpful, but also from an evidentiary standpoint, that is hearsay and it's not admissible. And then also, again, related to if you have someone coming in testifying on behalf of an association or saying, hey, I'm an economist or, whatever purported expert, there's requirements under Rule 702 and Watson v. Ford Motor Company and its progeny about, the admissibility of that testimony. And so that's not really, at least in our view, the license or the function of these customer public hearings. It's to hear from our customers about specifically these issues set forth in Act 41 and, any concerns or questions they might have about the particular rate case. And so those were generally our comments, just to provide some more structure to the customer public hearings.
Okay, so for yours, staff will have to go back and look at the language including language that the person must be a customer of the utility to testify at a customer public hearing, and also the customers must testify about information or facts within their personal knowledge. And I heard you reference Rules of Evidence 702. I wrote that down. I'll look and see if there's something I can steal from that.
All right.
Okay. Thank you.
That's it. Thank you, Ms. Boyd.
Yes, sir. Mr. Mustian?
No comments.
Thank you. Mr. Anselmo? No comments. Mr. Hall?
No comments.
Mr. Toraney?
No comments.
Oh, there you are. Wonderful. It's working. Okay, thank you. All right. Mr. Richardson?
No comments, and Piedmont agrees with the company's position.
Okay, great. So everyone, I wish I could figure out a way for our next forum to include this regulation with the others that were discussed under 191. I haven't figured that out yet. If I do, because I'm not a commissioner, so I can't consolidate proceedings. But if I can figure out a way, I will. If I can't, I'm sorry. We're probably going to have a separate one, break and do this. So, Mr. Hall, thank you for participating today. Mr. Mustian, good to see you. Thank you for participating. Mr. Wellborn and Mr. Trawick, thank you for being here, providing input. Mr. Anselmo and Mr. Burgess, thank you for participating today. Thank you, Mr. Richardson, for being present and participating. Mr. Toraney, last but not least, thank you for participating today. And we'll have to have a short follow-up session, if you all don't mind, for this one once I compile everything. Okay? Thank you. The chairman will be proud of me. All right, see y'all next time.